I believe you enjoyed your Easter holiday. It was a long weekend, but we have business to deal with, and that's the reason why we are back here this morning, to get this business done. I issued the direction last week, prior to the Easter holiday, that we return back today, which is the 13th, to deal with landowners' application. You will be given certain minutes to provide your either oral submission, or will it depend on the council how you will progress from here. There are quite a number of submissions that we need to look at this morning. But without further ado, council, I'll let you get us through this morning. Thank you.
Commission pleases. Commissioner, we return this morning for submissions in reply by the landowners. And Commissioner, before I refer to the list or to today's daily diary, perhaps I'll just allow our friends online to enter their appearances. Thank you.
Thank you.
Commission pleases. Veritimos is my name, initials MM. I appear with my learned friends Mr. D. Wood and Mr. Alavori. If the Commission pleases, for Curtin Brothers Holdings NG Limited and Balimore number 39 Limited.
Thank you.
Good morning, Commissioner. Perhaps
Morning.
just for the record, apologies, Mr. Keeper. Geroro, initial G, Council Assisting Commissioner. Mr. Keeper will basically be taking the lead this morning.
Thank you, Council.
Commission, please.
Please, the Commissioner, if I may just refer to the first matter on this morning's daily diary, that is agenda item number 1, which is leave application number 6 by Nani Lauren ILG of Tatana Village. They will be appearing through their representative, Representative Chairman, Mr. No Gaigo.
Thank you.
Yeah.
Morning, Commissioner.
Good morning.
For the recorder, my name is No. Surname is Gagwa. My grandfather's name is Laigo. I'm the chairman of Nene Lawina Incorporated Land Group. I represent Nene Lawina clan as chairman and spokesperson. Thank you.
Thank you.
Yeah. Mr. Commissioner, could I just make a note of something? Before the gentleman gives his submissions, if he's making any oral submissions, that we received very late, well, we received last night or the evening, some submissions from landowners, landowner applications 6, 7 and 12. The 7 was received this morning. We've spoken to Council Assisting and just want it to be recorded that we object to the submissions in their totality, that is all the submissions, and we just wish to place this on record that we object, and the Commission should note our objection. They're on a number of independent bases, the objections. The first is that they're contrary to and defy the ruling already made by you, Mr Commissioner Early, and signed by the Commission. They seek to ignore or defy such ruling, and to allow the defiance of such ruling would obviously be a serious error of law. Secondly, in any event, in many respects, they are not submissions in reply but seek to impermissibly adduce allegations which would be objectionable in any event. Thirdly, they seek to raise matters outside the scope or limits of the terms of reference, which you've indicated on many occasions correctly with respect, Mr Commissioner, is impermissible. You have restricted authority and jurisdiction. Fourthly, they request the Commission to make declarations and orders that are obviously not within the jurisdiction of a Commission of Inquiry. They're matters for a court of law. Fifthly, much of the submissions contain irrelevant material, and for each of those reasons independently, we object to the submissions. We ask that you note our objection and should ultimately rule at appropriate time that the material is irrelevant and should not be taken into account in terms of the submissions. That is, you should not take into account the submission for the purposes of the report. So we wish to place on record our objections before the submissions are commenced.
Council.
Yes, Commissioner. That is the position, Commissioner. We've had discussions with Mr. Bartimus, and our position is that we will let or allow the various applicants to make their submissions, and where Mr. Bartimus objects, like he has, the Commission can take note of that and then make an appropriate ruling at an appropriate time.
Thank you, Council. Thank you, Council Bartimus. I note your objection on the Lennon's application that you have addressed. But as Commissioner, I have also noted this objection must be recorded, and it will be included also in the finalization of the final report of this Commission of Inquiry. And for this reason, I will have to give the opportunity to the landowners to proceed with the submission. Thank you. Council.
Commissioner, please. My name is Noga Waraigo, the chairman of Nene Lawina Incorporated Language Registration number 504 Tatana Village, the legally recognized proprietor of subject land called Motukea Portion 2001, property number 5, and ILG Amendment Act 2009. Attached NL1 is the Motukea and adjoint portion before the invasion of Ketin Brothers Limited. All my information with facts are all attached within my file affidavit. I have no fear, therefore I clearly accuse Ketin Brothers Limited, Balimore number 39 Limited, by obtaining all the state list titles in corrupt manner. May I orally explain or elaborate instruments that Ketin Brothers Limited relied heavily or qualified, then executed the 1.2 billion land deal. The crystal errors revealed are why Council Whitmore stated that proper process are followed and no rush. It's totally false. The question I compelled to Council Whitmore is why two separate land posting state list titles were issued on same date, and why separate postings were consolidated and issued on single state list title, and also why LIRA land investigation report was made by legal applicant Mr. Gaudure from Balimore Village, who speaks Koitaban language, and name of the land is Ranubara. It's in Motucan language. This land posting state list title is issued on the same date with Motukea state list title because that's the posting that Ketin Brush Limited extracted gravel and newly built access road was developed within the underwater lease area posting 2991. They only paid a bribery payment to Mr. Gaudure. 2.5 million payment is done. And
I object, Mr. Commissioner. I have an objection. The submission shouldn't contain inflammatory language. This is supposed to be a submission properly in reply based on evidence, not just making accusations not based on evidence. So we object to the inflammatory language. It's not appropriate.
Councillor Assisting.
Commissioner, as I mentioned earlier, Commissioner can take note of the objection.
Sorry?
Commissioner, if Commissioner could take note of the objection and address it in the report.
I have made it clear that the objections have been noted, and he has also raised a point of the language that you use, but I give you the opportunity to complete your submission.
Thank you, Mr. Commissioner. Deed of release is also executed by lands senior officers. Is that proper procedures or corrupt activity? Another error or corrupt activity is in 2012. This attached document, attachment A, on the 27th November 2012, Balimore number 39 Limited, copies of conditional surrender of state lease on Annex A. It was surrendered on 27/11/2012. On the same day, the state lease title was issued. When it was issued, another state lease title was issued together. That was the title that I'm referring that they extracted, they posted and backfilled the International Wharf site. The International Wharf site is the underwater. On the same date of surrender, the new state lease title was issued, which consolidated 3 separate postings to 1 posting and issued on the same date. Can Council Whitmore confirm that it's proper procedures or rushing for set roadmap to project agreement? We need proper clarity on this. Otherwise, it's all fundamental elements to refer all persons involved to national fraud, including Mr. Justin Magan. One of the serious corrupt activity taking place is the initial transaction taken place. Through my file affidavit dated 5th December 2022, Thomas Daure Jones from Tatana Village, mixed parentage, but no lineage to 1899 deed forefathers, collaborated with late Mick Ketin, owner of Ketin Brothers, and used him as businessman, applied for business lease, and business lease title was issued on 1st February 1991, 99-year lease. 99-year lease lapsed in 2091. Just just after 4 months, not 1 year, 4 months, just after 4 months, Balimore number 39 purchased the land from Thomas Tower Jones with just only for lousy 370,000. Our valuable portions 2001 and 2195 was sold or transferred to Balimore 39 for, and Thomas Tower Jones received 370,000. Through my fact-finding after filing my affidavit, search on Google, and confirmed that both transferor and transferee are directors of Balimore number 39. That's totally conspiracy. It's organized, white collar. Both are conspirators. Can Council Timos declared my affidavit as scandalous, but in fact, his client and Tom Dower Jones are worse, scandalous, and who ripped our customary land, which seriously injured us, the landowners, previously and currently in an international wharf project agreement. When Tom Dower Jones was removed from Balimore number 39 Limited in 2001, I believe that's where his son, Mr. Nico Jones, was disappointed and revealed all the hidden arguments. My attachment for confirmation is attachment B. It's a Google information, which if you can confirm that Balimore number 39, directors are Lois Margaret Perkins, Peter Allen Lowin, Sir Michael Kettin, and Thomas Dower Jones. Based on these factors, I strongly compel to this Commission of Inquiry that if this Commission of Inquiry will, based only on valuation, Kettin Brothers Limited and Balimore number 39 Limited will still escape the serious allegations, basically stateless titles, conspiracy deal, and false survey plan of Posting 2991. Attached a false survey plan, attachment C. May I briefly explain the survey plans? If you will go to Annex C, the survey plan referred as catalog number 492214. If you can see that highlighted yellow is Posting 2991. Can Mr. Maleva confirm what's the hectare of that Posting 2991? Because we never seen the stateless title of 2991. 2991, I believe the initial hectare was 21 hectares. It's not the partially subdivided from the Posting 2893. It's the underwater list found in the Motukea. It was backfilled from the highlighted pink mark, which is Posting 2894. Gravel was extracted from that Ranubada land, and they backfilled the Posting 2991 and valued the 2991 and sold it to state for 722 million, the false valuation. And in 2015, another survey plan was done. It's computerized. It's not a physically conducted survey plan. When it was done, that Posting 2991 was converted or varied to Posting 3360, and within this redact version of index, paragraph 11, it says that the two state lists referred to in previous paragraph were issued on conditional surrenders of the state list of Posting 2893, State List Volume 49, Folio 229, and Posting 2991, the two state lists issued on subdivision of 2893, consolidate of one of those parcels within Posting 2991 with Posting 2991. This created a land parcel of 63.49 hectares and Posting 3360 for subsequent transferred to PNG Ports Corporation. The other land parcel, being Posting 3359, was retained by Balimore 39. In fact, Balimore 39 didn't subdivide that Posting 2893, the whole 154 hectares. It's only, they only decreased the number of 154 hectares to 99 hectares. But in fact, whole of the 154 hectares is still owned by Balimore 39. The Posting 2991, which was valued and transferred to state, it's an underwater lease which was backfilled and sold to state and with the false valuation. Conclusion, I therefore declare that all information stated in Ketin Barracks Limited and Balimore Number 39 Limited submissions are baseless and false on the instruments they relied on and executed in a corrupt manner. 2, therefore I declare that all state list titles issued to Balimore 39 should be cancelled and declared null and void. And also, all survey plans instrumental to state list title are also to be cancelled and declared null and void. 4, and also the board valuation to be cancelled and proper valuation to be conducted. 5, previous project agreement between state and Balimore Number 39 to be cancelled and declared null and void. New project agreement should be established between state and landowners of Motukea. 6, proper project agreement between state and my clan, Nene Lawina ILG, and leave applicants from Tatana village to consolidate and regroup as Motukea landowners, and state to be established and proper valuations and instruments to be executed in a proper dialogue. Lastly, if Honorable Prime Minister wants to take back Papua New Guinea, we, the silent landowners and citizens of Papua New Guinea, also need our traditional land back. Please have some sympathy. Thank you, Mr. Commissioner.
Thank you. Council.
Thank you, Commissioner. No further matters. If Mr. Gawa could be excused.
Thank you, Mr. Nogagoa. You can be excused from the table.
Thank you, Mr. Commissioner.
Thank you for your presence this morning.
Thank you.
Commissioner, the next matter is agenda item number 2 on the list, which is leave application number 7 by the Araira Lower Body community of Tatana Araira village. Commissioner, for this matter, the lawyer appearing for the applicant submitted their submissions via email. However, this morning when I spoke to the landowners, the clients or the applicant themselves indicated that they wanted to make oral submissions. So in the, as a matter of fairness, I will allow Mr. Noel Momoro to make oral submissions in relation to this one. Thank you.
I'd like to Just mention that you keep your submission to the time factor. At least 20 minutes could be the affordable time. So stick to that and go to the points that you are addressing. Thank you.
Thank you, Commissioner. Well noted. Good morning, Commissioner. For the record, my name is No, surname is Momoru, spokesperson for Araira Laurabara community of Tatana Araira village. Briefly, our lawyer John S. Guava of Sane Lawyers sent our submission through email to Senior Counsel Assistant Commission, Gibson Guerrero, early this morning. However, he's attending Supreme Court to receive a decision, so I'm standing in to read our submission verbally. I will now forward our submission. 1. Introduction. On behalf of the Araira Laurabara Community Group, its inhabitants, leaders, and authorized spokesperson, namely MSS No Momoru and Aleni, LA number 7, we humbly take this opportunity to make our brief submission, which course was made possible at the final remarks of Counsel Assisting the Commission of Inquiry, COI, Mr. Gibson Guerrero's closing submission, which gave the various landowner groups who had the privilege of being granted leave to participate in the COI, hence a final opportunity to make any submission in response to Counsel Assisting the COI, and lawyers for Balimore and Ketten Brothers Limited, or either of them respectively. It is imperative for the COI to take notice that LA number 7 applicants is quite peculiar and unique group as quite distinct from the rest of the other LA applicants. The latter are all deemed individual customary landowner groups representing various clans or tribal groups from either Tatana and or Baruni village in the National Capital District. LA number 7 represents the wider communal interest and aspiration of the present as well as future well-being of the people of Araira Laurabara community of Tatana Araira village in the National Capital District. 2. Synopsis. From the outset, the COI has embarked on a very significant investigative course, which was entrusted with the task as outlined under its terms of reference, TOR, and its statement of case. As a local communal group, having a population estimated between 1 and 2,000 inhabitants and dwelling within a closer proximity to the Motukea Wharf precincts and its surrounding environment, would obviously signal a more collaborative effort on the part of the government, including its relevant authorities or instrumentalities, to seriously consider such group of people whose general lifestyle insofar as would concern any social and economic factors, etc. With much respect, the group and its people have welcomed the opportunity given to it by the Marape Rosso-led government to participate in such a high-profile COI, as it was seen by the general community of Araira Laurabara as a timely response to so much of its confusion and uncertainty status quo over many years. The Motukea Wharf project has caused in the minds and well-being of this so-called marginalized community of people 3 critical issues. We do not intend to devolve into any lengthy historical analysis of Motukea Wharf, land issue, or dealings, except to raise certain critical issues that have been relevantly observed and noted in the course of the COI. Firstly, the Department of Lands and Physical Planning, as the duly authorized state instrumentality responsible for all land dealings in Papua New Guinea, let alone its involvement in the Motukea Wharf project, land dealings raises a lot of questions, including but not limited to such purported registration, approval of various land portion numbers associated with the Motukea Wharf, etc. One ideal example is noted in the submission by lawyers for Balimore and CBL redacted version at page 117, Annexure 1, Statement Number 3. On or around 17 February 1992, State List Volume 2, Folio 171, under which Portion 2001 was consolidated with adjoining Portion 2915 over area of 77 hectares, was issued to Tom Darrell Jones. It is clearly established that a purported Portion 2915 never existed, and yet it is referred in most of the purported land transactions as noted in paragraphs 4 and 5, respectively, of Annexure 1. However, it seems was referred correctly as Portion 2195 at paragraph 6 and 7. We thought of raising such issue on the basis that, though it may appear to be likely a typographical error, it is equally important to have some clarity on the purported anomaly. Secondly, the impacted community of Araira Laurabada, including its inhabitants of Tatana village in the National Capital District, have been greatly deprived of any opportunity to be consulted as genuine and legitimately affected community by the Wharf project. Such lawful and appropriate consultative process involving the surrounding impacted local communities, for that matter, the Araira Laurabada community and the wider Tatana village community, by the then authorized state instrumentalities such as Department of Lands and Physical Planning, in collaboration with Department of Environment and Conservation, would have been the most reasonable, lawful, and just approach in any given high-impacted project such as Motukea Wharf project. There was no proper and fair dealings involving the local surrounding impacted communities, who were deemed to be greatly affected by the ongoing movement of soil, rocks, dust, noise, including constant destruction to the surrounding marine and land environment. 4. Way forward. At this juncture, it is appropriate to mention on behalf of LA7 applicants that it respectfully welcomes the recommendation made by Council assisting the COI in their final submission for Balimore number 39 Limited and Mr. Justin Megan to be referred to the Royal Constabulary of Papua New Guinea for investigation for fraud. With great respect, such a course could possibly provide ample opportunity for any lost advantage for the general community of Araira and Tatana village inhabitants to have their social, environmental, and economical issues addressed more meaningfully and effectively in relation to such land dealings affecting the Motukea Wharf project, which includes the Big Motukea Island, Portion 2001, and Small Motukea Island, Portion 2195, respectively. The COI is respectfully invited to take notice of the fact that the various land dealings, including any purported acquisition of land, portions, or consolidation of land, involved as well as a significant amount of physical land excavation, backfilling, and or transportation of earth, soil, and rocks from certain land areas within the confines of Motukea land area to fill up, as well as extend the current Motukea Wharf land area, resulting in a significant extension of land area and or space and acquisition and registration under Balimore number 39 Limited. 5. Conclusion. In conclusion, the Araira Laurabada Community Group and all its leaders and inhabitants look forward to a fair and reasonable opportunity to be accorded to them by the government of the day to be able to directly benefit from the significant commercial spin-offs that are derived from the economical benefit from Motukea Wharf operations. Such a group of people whose lifestyle and daily welfare has been greatly impacted by the operation of the Motukea Wharf. Hence, it is only fair and reasonable for the government to seriously consider and to address such group of people's general economical and social welfare for the medium as well as long term. John Sinakagwawa, signed of Sunny Lawyers, for and on behalf of Araira Laurabada Community Group of Tatana Village, National Capital District. Thank you, Mr. Commissioner.
Thank you. Thank you for your presentation this morning. Council, you have anything to say?
Nothing in reply, Commissioner, if Mr. Moore could be excused.
Thank you. Mr. Mamoru can now be excused from the bar table. Thank you.
Thank you, Commissioner.
I make mention of agenda item number 3 on the list, which is leave application number 8 by Inahi Incorporated Land Group.
Good morning, Mr. Commissioner.
Good morning.
My name is Ripi.
Yes.
The name is Ripi. The first name is Noah. I represent the Inahi Incorporated Land Group from the beginning until today. Thank you, Worship. Mr. Commissioner. The submission we made is in response to Ketten Brothers' submission, Ketten Brothers and Balimore number 39 submission. I started from page 94 to 118. So this submission is regarding the response to Ketten Brothers' submission. Okay, Mr. Commissioner, in response to, just start with the introduction. That on behalf of landowner applicant party, Inahi Incorporated Land Group number 1153, we submit the following response in respect of the submission of Ketten Brothers NGL Limited and Balimore number 39 Limited in hearing number 80 dated 24th March 2023, respectfully. Background, thank you. Background, Inahi ILG joined the Commission of Inquiry into the sale and purchase of Motukea Wharf project as an interested landowner applicant party to exercise our legitimate land interests and property rights in the land portions within Motukea Wharf project area boundaries. The basis of Inahi ILG's application: 1. The COI inquiry matter land described Motukea Island. The basis of Motukea Wharf project area boundaries are clearly defined in a sketch map plan appended with its deed of attestation documentation dated 20th March 1899. 2. The current cadastral survey map, CAT map, plans described in portions 3359 and 3360, inclusive of the underwater leases, defining the Motukea Wharf project area illegally encroached or trespassed upon customary land belonging to Inahi clan. 3. Inahi clan has absolute tenant for life customary rights over usage and enjoyment over encroached upon land delineated in cadastral survey CAT map plans described in Motukea Wharf project area portions, thus have been deliberately deprived of their human rights and dignity by persons involved in the land dealings after 1899 without their consent and permission. The grounds of Inahi's application: Constitution of Papua New Guinea, Section 53, protection from unjust deprivation of property. Subsection 1, Section 54, special provinces in relation to certain lands, and except as permitted by this section, possession may not be compulsorily taken of any property and no interest in or right over an act of parliament, and unless the property is required for subsection 1, a public purpose, or subsection 2, a reason that is reasonable, justified in a democratic society, that a proper regard for the rights and dignity of mankind. Subsection B, the necessity for the taking of possession or acquisition for the attainment of that purpose for that reason is such as to afford reasonable justification for causing of any resultant hardship to any person affected. Section 54, special provisions in relation to certain lands. Nothing in this section 37, protection of law, of section 53, protection from unjust deprivation of property, invalidates a law that is reasonably justifiable in a democracy that has a proper regard for human rights, that provides, subsection A1, there is genuine dispute as to whether the land was acquired validly or at all from the customary owners before Independence Day, and subsection A, subsection 2, A2, if the land were acquired compulsorily, the acquisition could comply with section 53(1), protection from unjust deprivation of property. Evidence. The applicant party presented evidence by way of submissions and affidavits filed, which basically contain relevant vital Crown government land purchase documents, inclusive of their LTC decision and registered ILG documentation. It was submitted that the respective commission critically takes into consideration referring to vital evidences which in the Crown land purchase documents dated 1894 and 1899, that before the land acquisition, the purchase documents assets legitimately that the owners of Motukea Island were Vediho and Gaigo. These are their deceased ancestors, and at that material time, the basis of the two state leases described in Motukea Portions 3359 and 3360 Motukea Wharf project area. We also submitted evidence that the Land Titles Commission made a decision in 1960s based on the Crown purchase documents of 1894 and 1819 that declared Vediho's father, Daure Ibu, in Motu version, Tano Biagun, translated as landowner. It is also submitted that the manner in which the developer acquired customary and true compulsory acquisition under Land Act No. 45 of 1960 took advantage of the 1899 Motukea Island Crown purchase and Thomas Daure Jones business lease to justify its case in the Motukea Commission of Inquiry. Unfortunately, deprived the landowners from fully exercising their rights over their property or customary land that had been affected in the demarcation of the two portions of Motukea Wharf project area. We submit that as a result, if the Commission fails to consider that vital evidence in accordance with Motukea COI's statement of case, the Commission could be seen to have exceeded or refused to exercise its jurisdiction pertaining to TOR 1(d). Application of law and facts. Basically, we will discuss the grounds of the land group's application, hence the application to join as a party in Motukea COI was not objected to by the councils assisting the Commission in the Motukea COI proceedings. Scope of terms of reference (D). This is referring to the submission of Curtin Brothers on page 94. Paragraph 281. The scope of the terms of reference in 1(d) in the COI, which the landowners were granted leave, was sanctioned by the Prime Minister of Papua New Guinea in accordance with the statement of case to determine whether breaches were made in the Constitution. Paragraphs 282 to 283. The scope of terms of reference in 1(d) is restricted to the leave application landowner parties, but is guided by the statement of case, which not only applies to the landowner applicant parties, but also applies to all summoned parties or persons to respond accordingly. Paragraphs 284 to 290. The Commission is not limited by its terms of reference and did not exceed its powers of inquiry, hence the National Gazette notice statement of case justify the Commission to make its findings in every terms of reference to determine whether breaches were committed in the Constitution. Paragraph 291. It is understood that COI, the Commission of Inquiry, has no jurisdictions to hear or determine land disputes, but pursuant Section 27(4)(b) of the Land Dispute Settlement Act, limitations of jurisdictions, clarifies that if there was a court order made by the Land Titles Commission in 1966 declaring Vediho, Daure, and his father, Daure Ibu, as Tano Biaguna, or landowners within the vicinity of Ranu Hedadi. Ranu Hedadi portion is directly located between Koko and Motukea Island, respectively. This LTC determination directly affects Koko 1894 Crown Purchase Document and Motukea Island 1899 Purchase Document, and confirms the applicant Inahi Land Group's land interest in Motukea Wharf project area to be legitimate and justified. Section 4, Land Dispute Settlement Exception of Disputes. Where the head of state acting on advice is of the opinion that special circumstances exist that requires a dispute to be settled by means other than those provided by this act, the head of state acting on advice may, by notice in the National Gazette, declare that this act does not apply to the dispute. But Section 2, subsection D, that it is in the national interest that the dispute be settled in some other manner. Paragraphs 293 to 297. The COI lacks the jurisdiction to hear and determine land disputes, but in its findings, according to the statement of case and the terms of reference, confirms that the decision was made by the Land Titles Commission in 1966. The validity of the landowner claims to the land titles of a Motukea Wharf project could be justified. It must be noted here that no land in British Papua was acquired without proper land mediation or land investigation reports conducted. The government agents involved in at that material time were considered magistrates and judges, and Mr. Bramwell was a well-known commissioner of Land Titles Commission between 1950 and 1966. Paragraphs 298 to 301. The COI ruling on the objections filed by Ketten Brothers Limited, NG Limited, and Balimore No. 39 is seen to be forced upon them hence by law. Any person or persons, or in this instance, the applicant, Inehi ILG, landowner party, who complied under the Motukea COI statement of case and TOR willingly submitted sworn affidavits and submissions with evidence and should have been cross-examined under oath, same as the Prime Minister, Secretary of the Department of Lands and Physical Planning, which is the former Secretary, and the current Assistant Secretary of Finance, including the Valuer General. The material filed included critical chronology of important events that transpired before Thomas Dowry Jones' business list in 1988. The LTC determination in 1966 superseded the 1980s business list. In the submission of Ketten Brothers NG Limited and Balimore No. 39, it was assumed that there were professional errors and scandalous submissions submitted by Inehi Land Group. It's entirely based on assumptions and drawn on circumstantial evidence which cannot serve the purpose of the Commission of Inquiry unless the ILG's Dispute Settlement Authority members and persons occupying pertinent positions on the ILG are thoroughly cross-examined by the COI, which then would serve the purpose of revealing for the purpose and the ultimate outcome for which we are all answerable to the people of Papua New Guinea. Hence, PNG Port's acquisition of Motukea Wharf was financed with taxpayers' money. Paragraphs 302 and 306 to 306. Ketten Brothers NG Limited and Balimore No. 39 limited generalization of all the written submissions made by landowner parties could have been vetted diligently because the submission by Inehi Land Group is totally unique out of the other landowner parties. The primary reason why we conducted a search at Land Titles Commission was to determine whether Tom Dowry Jones and Balimore No. 39 Limited or Ketten Brothers NG Limited registered an application under Section 7 Land Tenure Conversion Act 1963 to comply with proper due processes before acquiring the business list title, which was then transferred to Balimore No. 39 Limited. If this legal process were not complied with, then the entire chronology of events leading to the current titles held by PNG Ports are in conflict. Hence, negligent acts of people responsible who fail to comply with due process could determine the land titles held and transferred to Balimore No. 39 Limited by Thomas Dowry Jones incompetent in its entirety. In this instance, Thomas Dowry Jones is the sole beneficiary. In our oral submissions, we alluded to our bona fide interests that were legitimately established in 1894, 1899, 1966, and 2018. In 2018, our land group duly registered Motukea Marakina without any objections whence it was published in the public media. Chronology of historical events, historical land dealings. A, our ancestor Vediho from Tatana vended cocoa in 1894. B, our ancestor Vediho from Tatana vended Motukea Island in 1899. C, our ancestors Vediho and his father Daure were identified, that is in the Motu dialect, Tano Biaguna, or landowner, in the edition of the Land Titles Commission in 1960 of Ranu Heradi. D, in 2018, a notice published in the National Gazette confirmed Motukea Marakina being a registered property of Inahi Incorporated Land Group, registered number 1153. No objection from Balimore number 39 and Ketten Brothers Limited. Annexure 1(9) today conflicts with the claim of Ketten Brothers NG Limited and Balimore number 39. Mr. Commissioner, in the submission of Ketten Brothers NG Limited and Balimore number 39, relied on and cited a case precedent decision of the High Court of Supreme Court of Australia in 1972 in support of their submission in Motukea COI. The case precedent cited in this instance cannot be applied because the landmass of Taugerema and Gayo compared to Motukea Island can be illustrated as a pin dropped in the ocean. 2, the presiding judges in the High Court of the Supreme Court of Australia in the decision truthfully confirmed the legitimate chief, Ahuya Ova, his people of Hoda village as the legitimate owners of land Taugerema Gayo acquired by the Crown between the 8th day of July 1885 and 8th day of October 1886. And the deeds of the acquisition were executed on the 25th day of October 1900 after a land investigation report was completed by government agents. The land was acquired for purposes of establishing the European colony township of Port Moresby. 3, the said landmass covers Paga, Toaguba, Erakone, Badili, Koki, Koridobu, Ella Makana, Eranese, Randuguri Police Headquarters, Hubert Murray Stadium, Government House, Catholic Church, Scouts Association, House Somali Champion Parade. Fortunately, Ahuya Ova's descendants and the current descendants of Hoda people today still exercise some form of land rights in the development of Port Moresby City and Motukea Wharf project. Land is no exception. 4, accordingly, their submission is full of contradictions, prejudice, hence, apart from Motukea Island's original survey boundary, Ketten Brothers NG Limited and Balimore through irresponsible manner deliberately demarcated customary land and today in Motukea COA attempt to clarify to be legitimate owners of the 2 demarcated land portions acquired from Thomas Dowry Jones under a business lease. 5, the extra customary land interests acquired apart from the original acquired land boundary of Motukea Island in 1819 by Ketten Brothers Limited and Balimore number 39 Limited within the boundaries of the 2 demarcated portions concerning Motukea Wharf project developments which were deliberately trespassed upon through compulsory acquisition process under Land Act 1966 number 45 must be diligently vetted by the respective COI. Hence, according to our response, you will identify that according to TOR 1 quadruple D contains many irregularities. 6, otherwise Motukea Wharf project is a major national impact project. Unfortunately, the state failed to conduct proper awareness programs or failed to conduct any proper environmental impact assessment programs or social mapping to identify legitimate owners concerning the future impacts upon the people residing within the surrounding boundaries of Motukea Wharf project area. Concerning the submission of Ketten Brothers NG Limited and Balimore number 39, the state in its final report must rebut their submission, hence numerous issues, both customary and legal, needs to be clarified. In concluding, the Inahi Land Group response to their submission, we would like to implore the Commissioner that the submission of Ketten Brothers NG Limited and Balimore Terminal Limited is prejudiced, full of contradictions, and should be dismissed in its entirety. Hence, under Section 53 and 54 of the Constitution, we seek the Commission's protection from unjust deprivation of our rightful inherited property. Thank you. Signed, Mr. John Sioni Gorogo, Dispute Settlement Authority, Inahi Incorporated Land Group. Thank you, Mr. Commissioner. That is all.
Thank you for your submission. Council, you have anything to say?
That we received the written submissions at around 10:30 this morning, and we will undertake to serve a copy on Ashurst right after the hearing. Thank you. If Mr. Rippey could be excused from the bar table, thank you.
Thank you.
Okay, thank you for your attendance this morning. You can be excused from the bar table. Thank you.
Commissioner.
Mr. Commissioner, sorry, before Council Sisting goes ahead, just for the record, although I think it's quite clear, but so there's no misunderstanding, our objections in relation to the submissions that we made earlier apply to all the landowner submissions, both written and oral. So we just state that for the record. we don't propose to get up and keep reiterating the objection, but if it could be noted for the record that they apply to all the submissions, both written and oral.
Thank you, Council.
Commissioner, agenda item number 4, that is leave application number 9, Ikubu Gavara and Namudia Horsberg. Thank you.
Good morning, Chairman.
Good morning.
My name is Gaba Govea, and I'm standing in for Namudia Horsberg and Ikubu Gavara for Laurina clan of Tatana village.
Yes.
But we have made submission, and it is in response to Ketin's submission that we have access to the copy that was given to us, and I would like to respond to that verbally. Reading the submission from Ketin's, I have noted that they're talking about the times of reference and the chronology of events that happened at Motukea. Okay, I want to outline to the Commission of Inquiry that when they talk about the terms of reference, they have listed all the things and they want the Commission to look at. And they wanted the Commission to stay in the framework of the terms of reference 1, quadruplet D. Okay, so I want to mention to the Commission of Inquiry that the word chronology does not come into the terms of reference as worded. So, and that is what I want to bring to the notice of the Commission of Inquiry. So according to Ketin's response, they've listed the chronology of events that happened to Motukea. Okay, Lauri and the clan of Tatana village are the landowners of, the genuine landowners of Motukea Island. And when you look at the Motukea Island issue and the Motukea Wharf, the Commission is to note that the area where the wharf, the area that was sold is not Motukea Island. So those are the things, there are a lot of things that have to be looked at. But just because of the terms of reference, Ketin insists that we have to stay in the framework of that terms of reference. For the purpose of understanding that issue, for the landowners, the landowners are in fact coming in for their concerns that there were no compensation or anything that was paid to the landowners, or the landowners were not entertained. So in order to touch on to that matter, I would have to look at the terms of reference 1, quadruplet D. So it talks about the historical land dealings. So it talks about the historical land dealings. It does not talk about the chronology of events. It talks about the historical land dealings. So the question is, who did Ketin brothers deal with? Who are the landowners they spoke to? Who are the individuals that they spoke to? That is not recorded in the submission. So according to the landowners of Tatana and the Baruni people who are coming in, when we were invited into the Commission of Inquiry to look at the land dealings, the landowners were never involved. So what will we bring to the Commission of Inquiry? What evidence will we present? We won't be able to present anything because we never had any dealings with Ketins. They never had any discussions with Ketins. So what are the corrupt dealings or things that people are assuming that happened? How can we verify that if we were never part of it? If the landowners were never part of the dealings? And when Ketin were arguing about the sale, they went all the way back to 1998. And when we went back to the original sale of Motukea Island, it was not relevant to the terms of reference 1, quadruplet D. So how can the landowners emphasize their interest on that area of Kashmir land when they are restricted to only the chronology of events? But the word is not written on the clause. 1, quadruplet D does not have the word chronology. It talks about the land dealings. So who did they deal with? Oh, was it because the land was all state land? So the landowners had no part to it. So that's how they looked at it. When the negotiations were done in 1998, portion 2001 and 195 were state land. So the landowners had no part to it. So the state was talking about a state land, the land that had a lease title. So the landowners would not be involved. But one point that the Commission of Inquiry has to see is the consolidation of land. So what Ketin did was, one part was state land, and when they extended, they decided to consolidate it. And they used this law in Land Act, Section 5. Why did they use Section 5? Asking the minister to declare the land not to be customary land. So maybe the excuse they gave was the land was already state land. But that state land, when they consolidated, part of it was customary land. So they decided to use that law, Section 5 of the Land Act. And they requested to the minister to declare that area not to be customary land, just because part of it was state land. But what about the customary land? Did they treat with the customary landowners? So when we're talking about the land dealings, there was no land dealings with landowners. They did not even talk to the landowners because they assumed that it was already state land. So how could the landowners come in? But looking at the area of consolidated, part of it is customary land. So they should have notified the landowners that they were getting the state land. The customary land. But that was never done. And then they used this application. Last time when I was doing my submission, I mentioned Brian Aldridge. And the reason why I mentioned Brian Aldridge is, he's the man who quoted in Harbour City Development. He said, the man who applies to the Minister for Lands to use Section 5 is an opportunist. Brian Aldridge, on his statement regarding Harbour City Development, he said, the person who applies to the Minister for Lands using Section 5 of the Land Act is an opportunist. So what is an opportunist? What is an opportunistic person? It's the person who takes advantage of things for his own benefit or his own gain. And he's the guy who said that. And he's the guy who made the application for Bagoda using that section in the Land Act. So we're looking at two different people. So when we are looking at whether the sale is genuine, then we have to look at whether the acquisition is genuine. Because that's the land they are selling. If the acquisition is not genuine, then they are selling a land that does not belong to them. So that's the area that I want to point out. The Laurina clan were never notified, even all the other landowners, they were not part of this deal. So when the sale was made, they were not part of it. And the thing that bothers me as a Motuan, the thing that worries me is Ketin brothers sold that land they got freely for $750 million. They got it freely using Papua New Guinea law, Section 5, injustice to the landowners. The question is, why did they use that law when they should have used Section 10, 11, 12, and 13? So what reason did they give to the minister to declare that area not to be customary land? So when to conclude, I want to ask the Commission of Inquiry to look at the land dealings. In fact, the last time I requested was to look at the acquisition document as stated by Ketin brothers in the submission. They said there was no objection done, but I want that document to be looked at for the reason. The landowners have to know the reason why that land was declared not to be customary land. And in conclusion, I want the Commission to note on its report that landowners were never part of this project from the beginning to the date of sale. So landowners have no evidence or whatever to put in the land dealings according to that terms of reference. So that is to be noted that landowners were never part of it. Even though the state knew that they were going to get the wharf starting from 1998, as stated by Kathleen, that there were independent surveys and all these things were done from that area. It was not only one year activity, it was done over a period of time. So if it was done over a period of time, why don't I see any landowner name in all those discussions? Nothing to do with landowners, but it's their customary land. So that is the area, the important point that I want the Commissioner to take note, that the landowners were never part of this Motukea Wharf project. Thank you, Mr. Chairman. No further.
Thank you for your submission this morning. Council, you have anything to say?
Thank you, Commissioner. If Mr. Gaba could be excused from the bar table.
Thank you, Mr.
Thank you. You can be excused from the bar table.
Next.
Mr. Commissioner, before Council Assistant goes, could I just note, and we'll put this in our reply submissions, there's an additional objection in relation to that submission that was just made, in that the person making the submission sought to give evidence from the bar table. That's, of course, impermissible. The evidence has to be based on the proper documents or oral evidence, sworn evidence given before the Commission, not by someone seeking to give evidence from the bar table. That's completely impermissible, and it would be an error of law for the Commission to consider it. You must evaluate, as you've said, the evidence properly before the Commission, and someone getting and making a submission before the Commission doesn't constitute evidence. So that's an additional objection that's particularly relevant to the submission that's just been made.
Thank you, Council. That has been taken. I have taken note of that. The purpose of this hearing is to allow the landowners to give in the submission, but the objection have been noted, and it will form the part of the final report that, as I have stated earlier on. Thank you. Council.
Thank you, Commissioner. Moving on to item number 5, leave application number 10, filed by Chief Haruka Morima, Chairman of Kaiwaga LG Sasiva. Commissioner, Mr. Haruka is not present this morning, but I just wanted to mention it for completeness' sake. And also for the record, he has not filed any written submissions.
Thank you.
Thank you. I move on to agenda item number 6, which is leave application number 11, filed by Mr. Gaudu Ray of Tanamotu Clan, Baruni Village. Thank you.
Thank you.
Good morning, Mr. Commissioner.
Good morning.
For record, name is Gaudi Ray, the chairman of Tanamotu Clan from Baroni Village. Mr. Commissioner, for submission, we would be relying on our submissions filed on the 1st of March after the ruling was made on the submission by Keaton Brothers, and further supplementary submissions were done after the redacted version of submission was received on Tuesday, which I would be seeking leave of this commission to distribute my submissions and read through both submissions while the copies can be followed through. Sorry, Associate, you can please send a copy.
Thank you. You can proceed.
Thank you, Commissioner. Commissioners have stated we would be actually relying on our submission filed on the 1st of March and also on a supplementary submission just been said. This is our submission in response to submission by Ketten Brothers Limited and Balimore 39 Limited. This is the submission in response to the submission by Ketten Brothers and Balimore 39 regarding terms of reference 1 quadruple D. Mr. Commissioner, in a nutshell, Ketten Brothers and Balimore 39 seek to assist the Commission of Inquiry by seeking to object materials provided by the landowners. The basis of this approach they contend is that most matters raised by landowners are outside the terms of reference. B, Commission of Inquiry lacks jurisdiction to hear matters of landowner disputes and landowners' issues in Motukea, such as issues of indivisibility of title and compensation. Paragraph 3, the only question or issue that has arisen that should be the compass that would guide the Commission of Inquiry is the terms of reference, which reads, what are the historical dealings from time of acquisition of the customary land up to Motukea Wharf project. Paragraph 4, firstly, Ketten Brothers and Balimore 39, being the beneficiaries that commercialized on the sale of Motukea Wharf should be in a better position to assist the Commission of Inquiry in answering that question. They have intrinsic knowledge of any customary dealings on the land. Instead of answering the question, it's quite frustrating to notice that in paragraph 1 of their submission, they seek to assist the Commission in relation to these terms of reference. However, in the body of their submission, they basically seek to object landowners. They have not even attempted to answer the question in the TOR. To begin with, I applied to be granted a leave and was granted leave on the 27th of October based on terms of reference 1 quadruple D. If Ketten Brothers and Balimore 39 had issues with my application, they can seek judicial review on its granting rather than objecting to its contents. I don't want to labor too much on the Commission of advocating on matters that are too technical in terms of evidentiary materials provided by me. However, I would make it clear that at the outset, the matters in my affidavit are facts that support the portion that Motukea Wharf was built with the causeway on our customary land. And there was no dealing whatsoever with Ketten Brothers Limited or Balimore 39 or the state. Firstly, in my affidavit, I clarified my standing in paragraphs 1, 2, 3, and 4 on my claims position in owning land and conducting dealings with Ketten Brothers Limited and Balimore 39 in the past. The facts support my credibility on whatever assistance I gave to the Commission of Inquiry regarding the TOR. Logically, flowing from that, I attempt to assist the Commission in paragraph 11 and 12 of my affidavit by deposing factual matters of steps that had been taken by my client as customary landowners to be part of the acquisition process. The matter deposed there are within the scope of the terms of reference where it goes to answer the question posed that there was no land dealing with landowners during the acquisition by the state, unless Ketin Brothers and Balimore 39 and PNG Ports can assist the Commission by providing an answer that is contrary to mine, that is a fact that stands unchallenged by them. From paragraph 13, 14, 15, 16, 17, 18, 19, and 20, I depose matters that are relevant and within the TOR. Why am I saying this is because, A, the causeway leading into the wharf, the main wharf in Motukea, was part of the sale by Balimore 39 and PNG Ports. That fact was deposed by Mr. Smart in an affidavit which I attached as Annexure GR10. My clan had customary interest in the land. However, we were never part of any dealing in regards to that. How did Balimore 39 own that land consisting of the causeway? Was it a wasteland where it just came in, claiming it, and sold it to the state as part of Motukea deal? To assist the Commission of Inquiry, and that is something where they should disclose instead of becoming too technical. They themselves have not answered the terms of reference by becoming too technical. See, the affidavits I have annexed as GR10 and GR11 give inside details on the acquisition of the causeway, which was part of the Motukea sale. This affidavit deposed matters of facts. Under Section 44B of the Evidence Act, these two affidavits are admissible as evidence, and the Commission should take judicial notice of this. The matters deposed in this paragraph are within the scope of the terms of reference, where it goes to answer the question posed that there was no land dealing with landowners during the acquisition by the state, specifically in regards to the causeway leading into the main wharf. I understand and appreciate the jurisdiction of the Commission of Inquiry. The matters deposed by my affidavit do not relate to any disputes over customary ownership that would warrant the jurisdiction of the Land Dispute Settlement Act. This is not the right forum. Or raising landowner issues and staking a claim for compensation. According to the terms of reference, I have provided factual matters that in a nutshell answer the question posed: what are the historical land dealings from time of the acquisition of the customary land up to the Motukea Wharf project? I have answered this question to be negative. The Commission of Inquiry should also take note that Ketin Brothers and Balimore 39 have not sought in any manner to assist the Commission of Inquiry by answering the question posed in the terms of reference, or the TOR. Instead of doing that, they are attacking technicalities and even warning the Commission of Inquiry that it might make an error of law if it considers matters by landowners that are not within the TOR. The question of considering or excluding matters that are not within the TOR is the role of the Commission of Inquiry. The Commission of Inquiry should not be told how to do its job by Ketin Brothers Limited and Balimore 39 in the guise of submission claiming that they are assisting the Commission of Inquiry. To fruitfully assist the Commission of Inquiry, they should assist by filing the necessary materials to answer the question posed by the terms of reference. I submit this specifically on issues taken on materials provided by me on behalf of Tanamut Clan of Baruni Village. Mr. Commissioner, I will take you through also the supplementary submission. Supplementary submission in response to the redacted version of submission by Ketin Brothers Limited and Balimore 39. This submission in our supplementary submission in response to the redacted version of submission by Ketin Brothers Limited and Balimore 39 regarding terms of reference 1 quadruple D. We submit that Ketin Brothers Limited and Balimore 39 are still not assisting this commission of inquiry by objecting or denying our landowner constitutional rights by defining the amended terms of reference 1 quadruple D to only suit how they, Ketin Brothers Limited and Balimore 39, acquire our customary land, which now houses the Motukea Wharf. Ketin Brothers Limited and Balimore 39 also failed to see in evidence we submitted and filed on the 18th of October 2022 in paragraph 15 and 16, and submission in response to Ketin Brothers Limited and Balimore 39 objections filed on the 1st of March that there is a customary land title where the Motukea Wharf causeway was built on, but instead opted to quickly move a motion for the submission with the schedule of objection to disqualify the landowners and say their evidences are inadmissible. We say this is not fair and has caused injustice to our legal customary title. We also submitted Annex 1, the chronology of Ketin Brothers Limited and Balimore 39 version of land dealing from item 1 to 9 should be set aside and refused. It is a clear indication and demonstration of how our customary land was illegally acquired by Ketin Brothers and Balimore 39. Mr. Commissioner, you will also note that there is no notation of publication by way of gazettal notice of objection which normally in Lands Act allows for any objection up to 90 days is called for before a final gazette notice put up for a successful applicant for the stateless title. There is also no evidence of the gazettal notice being published neither in the Post Courier or the national papers, giving the opportunity to ask the customary landowners to object to the state lease applications by Ketin Brothers Limited and Balimore 39. Again, this is a clear indication of land being illegally acquired, where customary land rights were hijacked by individuals for their own benefit and the rightful landowners being marginalized. Land portions 201 and 2915 are the customary land dealing Ketin Brothers Limited and Balimore 39 acquired from Mr. Thomas Jones, and that is the only land transaction we see legal on Motukea land deal. Ketin Brothers Limited and Balimore 39 Annex 1, points 1 to 4. Apart from that, we also submit that Ketin Brothers Limited and Balimore 39 in the Annex 1, points 5 to 9 should be noted and investigated as to how our customary land, which initially are not part of Motukea, but are the land adjacent, are the adjacent customary land being acquired by Balimore 39 and Ketin Brothers. And why were there no customary landowners involved or consulted? Did the land just float in from the ocean and does not qualify for a land ownership? Paragraph 8. We answer this by saying Ketin Brothers Limited and Balimore 39 have enriched themselves in greediness and dishonesty in illegally acquiring our customary land in guise of an underwater lease, applied for by one Mr. Brian Ulrich, who is the principal of AKT Associates, who was once a land consultant for Ketin Brothers Limited and Balimore 39, and then a consultant from PNG Ports, who is also, with information we gather, is a land board director with lands and physical planning, who meets and sits in the land board for assessment of submission and give approvals for the state list titles. Mr. Commissioner, we also note and we submit that The Motukea Wharf project is a significant level 3 project, similar to the PNG LNG project, where legal landowners' participation was structured into the entire project concept or module. Similarly, the Lay Wharf Basin project, where landowners were invited to participate in structuring of the entire project. This similar level 3 project was successful and never referred to the Commission of Inquiry like what we're doing with Motukea Wharf. Finally, Mr. Commissioner, with that, we summarize in a closing submission and submit to that Kettle Brothers Limited and Balimore 39 have purposely objected to our factual evidences submitted in order to avoid being investigated on why there was no land dealing with landowners during the acquisition by the state. No landowner consultations were done in the entire acquisition process. With that, we submit that Kettle Brothers Limited and Balimore 39 submission be set aside or refused, and our landowner application and submission be considered to assist the Commission into its findings. Submitted respectfully and in full landowner heart. God bless you all. Thank you.
Thank you for your closing submission. Council, you have any comments to make?
Commissioner, nothing further. If Mr. Gaudure could be excused from the bar table.
Mr. Gaudire, thanks for coming in this morning to give your submission. You cannot be excused from the bar table.
Thank you, Commissioner.
Thank you.
Commissioner, I move on to agenda item number 7 on the daily diary,
Yes.
which is leave application number 12, filed by Mr. Kennedy Kevin, Land Chief of Narina Clan.
Thank you, Honorable Commissioner and Council's Assistant. Commission, please, I state my name for the record. I am Kennedy Kevin, the next of kin Land Chief of Kevin Rarua.
Yes.
I stand on behalf of myself and all direct descendants of Igorashina of Narina Clan, Tatana village. Honorable Commissioner, I submitted my submission yesterday, and today, if Commission pleases, I'd like to present it.
Thank you.
Honorable Commissioner, I'd like to take this opportunity to make my response to the objection which was raised by the Council for Kettle Brothers during the presentation of my submission on Friday, the 10th of March, 2023. It was brought up during my submission that my statement saying my amended submission filed on the 11th day of November, 2022 was never objected by Kettle Bros. By law, I was supposed to receive a formal objection, which Balimore number 39 and Kettle Bros lawyers failed to do so. Even on the day they mentioned the objection during my submission, Council Assistant confirmed that he could not locate the objection. Therefore, since the objection was not formally served and was not found in the Commission files, this gives clear proof that the objection never existed. Thus, my statement and my amended submission stand. This leads me to say that the assertion made by Kettle Bros and Balimore number 39 Limited, stating their stance on 1 quadruple D and the ruling, has no effect on my amended submission, which they failed to formally object. I'd also like to point out that nowhere in the amended terms of reference does it say that the landowner's interests are only limited to or should only be related to 1 quadruple D. Even if they are saying 1 quadruple D does not completely cover my interests as the genuine landowner, the whole scope of the term of reference does. Even from the previous hearing on the test day, the 6th of April, 2023, After Council Assistant Mr. Gibson Guerrero gave their submission, your Honorable Commissioner, while giving his closing remarks, stated that we should not be focused on just one part of the amended term of reference, in this case, 1 quadruple D, rather it should be seen as a whole. The foundation of the amended term of reference is the law governed by the Constitution of the Independent State of Papua New Guinea. Honorable Commissioner, as a Papua New Guinean, the law gives me my constitutional rights and protects my interests. Sadly, those rights were not respected when Ketim Bros and Balimore Namatedina Limited, without the genuine landowner's consent, trespassed into and sold our customary land, which, Honorable Commissioner, I make it precise to this Honorable Commission that it was not Motukea that was sold. Motukea only consists of portion 2001 and 2195, which make up 77 hectares. The land that was actually sold is outside of that 77 hectares and is our customary land, Rarove. And by doing so, Honorable Commissioner, they did not follow the correct or compulsory procedures under sections 10, 11, 12, and 13 of the Land Act 1996. In my amended submission, I also pleaded the protections under the Constitution of Papua New Guinea, the Pacific Islanders Protection Act 1875, and the proclamation made by Her Majesty Queen Victoria on the day of November 1884, which no competent jurisdiction will ever have the right to overrule. Honorable Commissioner, all these protections were established by the power of law to protect our law and our constitutional rights. Therefore, my interests and my claim are valid and have heavy bearing in this inquiry. Honorable Commissioner, in conclusion, with respect to natural justice and the law, since the genuine landowner was not consented before selling and making development on our land, Rarove, it is right and just for the genuine landowner to be respectfully recognized and compensated accordingly. Thank you.
Thank you, Mr. Kevin Kennedy, for your brief submission. You can be excused from the bar table. Thank you.
Thank you.
Commission places, Commissioner, the next agenda item is agenda item number 8, which is leave application number 13, filed by Mr. Michael Mark Jones.
Yes.
Commissioner, Mr. Michael Mark Jones was supposed to have appeared via video link, but apparently is not online, so Commissioner will move on to the next item.
Yes.
Which is agenda item number 9, which is leave application number 14, filed by the Nenehi clan of Tatana village, particularly by Mr. Patrick Aino. Commissioner, Mr. Patrick Aino is not present this morning, but I just wanted to mention that for completeness' sake. And he has not filed any written submissions either. I'll move on to agenda item number 10, which is the last item on the list, which is leave application number 15, filed by Mr. Soga Siai. Mr. Siai is present, so I'll invite him to the bar table to enter his appearance and make his submissions accordingly.
Thank you.
Good morning, Mr. Commissioner. A nice day. And I I'm very, very glad to be part of this inquiry into the Motukea sale. And coming to the conclusion of this inquiry, I want to say something. Thank you. Firstly, I humble myself to the God Almighty, who is the creator of heaven and earth. I glorify him at all times because he is always to be respected. And therefore I humble myself to this floor of commission. I have complete respect to the commission, and I'll come into the inquiry. Repeating, my name is Sogosiai, Secretary, Elder, and I am the direct descendant of Vedi Hodare, the recognized Fairfax Harbour landlord and controller. Repeating, I am the descendant of Vedi Hodare, the recognized landlord and controller of Fairfax Harbour. Subject, landowners of Tatana people were not involved. Yes, the principal recognition of Motukea Island sale. As acknowledged in 1899, Motukea Island was owned by Vedio and Raigo of Tatana village. Acquisition certified by George Ruthven Lee Hunt on the 20th March 1899 and registered number 203, volume 1, dated 11 April 1899, refers. What was the value of the land sale of Motukea at that time? I understand that Papua New Guinea got its independence in 1975. The human rights of Papua New Guinea was declared in 1975. What else will I say? Transactions taken place. How did the late Tom Dara Jones and Catherine Brose became landowners of Motukea land? Repeating, how did the late Tom Dara Jones and Catherine Brose became landowners of Motukea? Vediho and Raigo still maintain their possession as original landowners of Motukea. For the commission of inquiry into Motukea sale, due to the terms of reference order, I have selected Annex 1B, 1 quadruple D. The landowners and land dealings. What are the historical land dealing from time of acquisition of customary land up to the Motukea Wharf project? The Tathana landowners of Motukea, as confirmed in 1899, acquisition still stand firm and request through this Commission of Inquiry to the head of the government, the Prime Minister, Honorable James Marape, for compensation. Finally, I would want to state that state that the government must review all the past land sale acquisitions and should retain or transfer the landowner rights back to the original owners as recognized. Thank you.
Thank you, Ms. Sogoziai, for your submission this morning. You can be excused from the bar table. Thank you.
Thank you.
Council?
Thank you, Commissioner. Commissioner, those are all the matters for today. We have no other matters. That being the case, if I may kindly request that the hearings be adjourned to tomorrow for submissions by ashes in reply. Thank you.
Thank you. Thank you for your presence this morning. We'll return back tomorrow at 10 a.m. For the Keating brothers in response to the council assisting closing submission. And until I see you again tomorrow at 10 a.m., Associate, you can now adjourn all the hearing to 10 a.m. tomorrow. Thank you.